5 seconds to go. Start. It is stated that even today, if investigation is done by a police officer or another, he can only file a complaint and not a police report. Therefore, the above mentioned test is irrelevant and inapplicable. Absurdity that arises is due to two investigations being conducted, one by a police officer and the other by the authorities specified under section 48. An additional point has been raised that the difference between a complaint under the PMLA and a charge sheet under the CRPC is only a nomenclature norm and they are essentially the same thing. Thus, basing the determination of whether one is a police officer or not on the nomenclature is not proper. In respect of interpretation and constitutionality of section 50 of the PMLA, our attention is drawn to section 52, which pertains to recording of statement of a person summoned during the course of an investigation. In that, section 53 posits that such person needs to state the truth. Further, he has to sign such statement and suffer the consequences for incorrect version under section 63(2)(b) and the threat of penalty under section 63(2) or arrest under section 19. It is true that the ED manual may be an internal document for departmental use and in the nature of set of administrative orders. It is equally true that the accused, or for that matter, common public, may not be entitled to have access to such administrative instructions, being highly confidential and dealing with complex issues concerning mode and manner of investigation for internal guidance of officers of ED. It is also correct to say that there is no such requirement under the 2002 Act, or for that matter that there is nothing like investigation of a crime of money laundering as per the scheme of 2002 Act. The investigation, however, is to track the property being proceeds of crime and to attach the same for being dealt with under the 2002 Act. Stricto sensu, it is in the nature of an inquiry in respect of civil action of attachment. Nevertheless, since the inquiry in due course ends in identifying the offender who is involved in the process or activity connected with the proceeds of crime, and then to prosecute him, it is possible for the department to outline the situations in which that course could be adopted in reference to specific provisions of 2002 Act or the rules framed thereunder, and in which event what are the options available to such person before the authority or the special court as the case may be. Such document may come handy and disseminate information to all concerned. At least the feasibility of placing such document on the official website of ED may be explored. Serious grievance has been made about the vacancies in the appellate tribunal despite the serious prejudice being caused on account of provisional attachment order and in some cases taking over possession of the property so attached. This grievance, even though genuine, cannot be the basis to test the validity of the provisions of the 2002 Act or to question the efficacy of those provisions on that account. Stop.